report.
My Lord, my Lady, I was just making a point about the evidence as to whether Jean-Rony John Charles had left the Bahamas, and I think in answer to my Lord Kitchen's question about whether the point had been taken below, I said yes, it had, but just to make that good, to give you a reference. So the respondents, but appellant in the Court of Appeal's skeleton, paragraph 34, page 661, and also, if I may, just take you to a passage in the transcript of the Court of Appeal. We do set this out in our written case, but I'll give you the references. It's page 958, lines 11 to 22. If I can just ask the board to turn that up. Line 11, these are the submissions of counsel for the appellant, so the government. And they're making a point. The point comes to this, my Lord, is that there is an admission from his own counsel that he's been the beneficiary of several travel documents in the past. So it certainly should have raised the issue as to whether or not the affidavit evidence of the sister, which the judge said was uncontroverted, should have been used as a basis to make these findings. And the point is then taken up by the Court of Appeal when Mr. Smith makes his submissions later on. It's 1265. If I can just ask the board to turn that up. And line 12, Mr. Smith, I think, posits that if Jean-Rony John Charles had left the Bahamas and re-entered without permission from an immigration officer, he could be prosecuted and deported. And Justice of Appeal Barnett then says at line 22, he questions whether that concedes that there ought to have been a factual inquiry. Then over the page at 1266, line 25, Justice of Appeal Barnett refers to the judge's finding in paragraph 38. That's the finding that the judge makes, that it's a finding of fact based upon an affidavit. And Justice of Appeal Barnett says that the person has no basis of knowing. And then you see the President refers to it as hearsay. And then Mr. Smith is then bound to accept that if Jean-Rony John Charles had travelled out of the Bahamas when his sister was young, she wouldn't have known about it. But I highlight that simply to make the point that we say is an example of the judge falling into error and making effectively a factual finding of something that he described as being undisputed without giving the respondents an opportunity to challenge the evidence. I was then just going to briefly come to the return to the writ, which is the second piece of evidence the judge relied on at first instance. The board has that page 52 to 55. The return itself, paragraphs 3 to 6, provides the details of the arrest on the 18th of September 2017. So you have adult male, Haitian national, name given as John Charles, date of birth 1st December 1985.
Remind me of the page, please.
52 through to 55 is the return, my Lord, and this is paragraphs 3 to 6, page 52. If I can ask the board to turn to the immigration profile form, which is annexed to the return, page 56. So that records the date as the 18th September 2017, name John Charles, nationality Haitian, date of birth December 1st, 1985, place of birth Nassau, sex male, location, address, Fire Trail Road, and then two-thirds of the way down, I confirm that the information given is correct, and then there's a signature, John Charles.
Is that a photograph in the top right-hand corner?
My lady, it appears to be, but I have not seen the original. I can perhaps take instructions because there will be one on file.
Well, that would presumably clear up whether it's him or not.
Well, my lady, it may and it may not. And the reason I say it may not is because there was, when the emergency travel document was issued, there was an issue as to the photograph that was attached to the emergency travel document. The photograph that was, my understanding is that the photograph that was issued initially for the emergency travel document was a photograph that came from the respondents' files. And when that was presented to the appellant's representatives, issue was taken with the emergency travel document because it referred to the appellant as being of Haitian nationality, and also a point was taken on the photograph, and it was said that this is a photograph of many years before, so it doesn't show a likeness of the appellant now. And my understanding is Mr. Smith provided his own photograph of Jean-Rony, John Charles photograph used in the emergency travel.
Yes, I think that you had a photo of him aged 18. Is that right?
I think
and
teenage.
he's now aged 31.
My lord, yes.
Yeah. Again, one would have thought that a brief comparison of the two photos might give you some indication who you were dealing with.
My lord, on the immigration profile at page 56, there's never been any suggestion that is not Jean-Rony, John Charles's signature, or it has never been suggested that the information set out there is wrong, and there's been no explanation given for the inconsistency between the information set out there and the information set out in Miss John Charles's affidavit. Going back to the return, page 53, paragraph 10, the name and date of birth again was confirmed as correct, we're told, on the return, on the roll call before being removed to Haiti. So if, as my learned friend on instruction says, it was a mistake as to the date of birth on the immigration profile form, well, it was a mistake that on the evidence was repeated on the roll call before getting on the flight. So assuming for present purposes that the appellant is the person that was arrested, removed, and then brought back to the Bahamas, these discrepancies have never been explained. Without resolving those issues, we submit that the judge couldn't fairly grant the final relief that he did, and the Court of Appeal was plainly right to uphold the appeal on that basis. They're the sort of comments for the time being and submissions on those two bits of evidence I wish to make. I'll move now to the appellant's four arguments. First argument is the court's jurisdiction under Article 28 of the Constitution. The appellant's contention is effectively that the Court of Appeal misconstrued the requirements for claiming constitutional relief under Article 28 of the Constitution. Our response to that is set out in paragraphs 16 to 20 of our written case that starts on page 1541. And what we say there is that this is essentially a straw man argument. There was no dispute in the Court of Appeal that an application for constitutional redress could be brought in the same action as an application for habeas corpus. The issue for the Court of Appeal that they deal with is whether the procedure adopted by the judge was fair. And although the reasoning in the two judgments of Justice of Appeal Barnett and Isaacs is slightly different, the point that both judges make is that the judge at first instance ought not to have proceeded to determine the application for constitutional relief in the way he did, having dismissed the habeas corpus application. And we submit that's a conclusion the Court of Appeal was plainly entitled to reach. There's a case that both sides rely on before the board, and it was cited in the Court of Appeal. It's a case of Jane Doe and the Attorney General of Guyana. We have referred to it paragraph 9b of our written case, but your lordships and my lady have it in the authorities bundle at page 2336.
Lord Diplock.
My lord, it is. It was appealed to the board from the Court of Appeal of Guyana. The issue was the procedure for claiming constitutional redress, and the relevant passage is at 2347, where Lord Diplock endorses what was said in an earlier case by Mr. Justice Warrington, namely that where the Constitution merely provides for an application and doesn't say in what form that application is to be made, as a matter of procedure, it may be made in any way in which the court can be approached. Lord Diplock then went on to say at paragraph B, the procedure adopted must be such as will give notice of the application to the person against whom the redress is sought and afford to him or it an opportunity of putting the case why the redress should not be granted. And the short submission from the respondents is that we were not afforded this opportunity in the present case. The respondents attended court on the 19th of December to respond to a habeas corpus application. The respondents were not in a position to respond substantively to the application for constitutional relief. The best the respondents could do was to take a preliminary point that the appellant had alternative remedies and should be debarred from seeking constitutional redress on that basis. Now, much has been made by...
What was the alternative remedy that you
by way of writ for damages. Effectively, the avenue that the appellant has pursued after the Court of Appeal gave judgment. So on the 27th of November 2018, the appellant has issued a writ claiming damages, amongst other things, for false imprisonment, detention and removal. And in that, it's not simply damages, it's not simply damages for false imprisonment and unlawful removal. It is damages for breach of his constitutional rights. And go to the point my Lord Reid put to my learned friend this morning, that effectively this appeal really, when one boils it down to its basics, is a matter of case management. Well, my Lord, my Lady, respectfully, I would agree. What the Court of Appeal effectively was saying is that, given the state of the evidence in this case, what ought to have happened is that fresh proceedings ought to have been issued by the appellant by way of a writ, which would have allowed discovery witness statements, and that would have affected a fair resolution of this issue. And
didn't they also issue a different originating motion with a return date for February? And I think that's at 98. Oh, no, there was a different one.
That's for contempt.
I meant, sorry, the one at 148. How does that fit into the 148 notice of motion for constitutional relief under Article 28? That was issued in February. Where does that fit in with where we are now?
So that's issued 5th of February 2018. So that's after the judge gives judgment and prior to.
This is not the stay.
I think, although I'll be correct in front, I think just looking at the date, that appears to be a further notice. That the intention being that should be determined at the stay hearing, because the 5th of February was the first hearing of the stay summons, where Mr. Justice Hilton ordered the release of the appellant from detention. So it looks as though, but answering the Ladyship's question, what has happened to that motion, the answer is Mr. Smith may be able to shed some light on it.
In answer to the lady, it was put on hold at the hearing for the stay application, pending the determination of the stay application and the appeal.
It's all about the stay.
And nothing further has happened with it.
So this is stayed pending the outcome of this appeal to the board?
At the time, there wasn't an appeal to the board. There was going to be an appeal to the Court of Appeal. It was just during the stay application. So we agreed to put it on hold pending the outcome of the stay application. And nothing has happened to it since. Yeah. So, lady, the first relief that was sought was to set aside the ex parte stay order that was given. That's at page 149. So what happened was that we tried to agree the terms of a stay or otherwise. Couldn't agree. Finally, there was a complete hearing on the stay. And all of this was put, the ex parte stay order fell away when there was the inter partes hearing on the stay application. And some of our objections that are contained, or the points taken in this originating motion, were then taken in opposition to the stay application during the inter partes hearing.
But the relief that this seeks at 8 and 9 seems now to overlap with the writ.
It does, my lady.
Yes.
does. Yes. But my lady, this was with respect to his having been rearrested on his return to the Bahamas under the travel document.
Once again.
So when he returned back to the Bahamas on the travel document, he was then arrested by immigration and taken back to the detention center. And they wouldn't allow us to see him. Couldn't even take a statement from him for the purpose of the stay application.
I see. So there isn't an overlap in the sense that 8 and 9 relate. Sorry.
Lady, there might very well be, because in the writ that we subsequently issued, we comprehensively included everything that had happened to him from inception. So this hasn't further been pursued.
Thank you.
Because it was simply agreed to put it in advance pending the stay application. Oh, over here. Sorry. Thank you, Lady.
So, returning to the point of that we take from Jean-Du and notice, much has been made by my learned friend that effectively the respondents had notice because they had the affidavit from Ms. John Charles and emails from around the 6th of 7th of December from Mr. Smith. Well, with respect, that is a far cry from making an application for constitutional relief. What is said in Ms. John Charles's affidavit is there has been an infringement of Mr. Jean-Rony, John Charles' constitutional rights. Now, the respondents is not to know how the appellant is going to seek to vindicate those rights, because he could have, as he has now done, sought to issue a writ, could have made an application for constitutional relief. None of that was done until the morning of the habeas corpus hearing on the 9th of December. And the respondents cannot, in my submission, be criticised for not coming to court on the 9th of December to respond to an application for constitutional redress that they did not know was about to be filed.
May I just ask this? If one were to come to the conclusion that there was no answer, would it matter that you were taken by surprise in that sense? I mean, if ultimately the court were to come to the conclusion, or this panel were to come to the conclusion of the board that there is no answer, does any of this make a difference?
My lord and my lady would have to be satisfied that there was still fairness in the procedure and in the hearing, and it would be very difficult to make a conclusion that there was only one answer in this case if the respondent couldn't be heard, had not been heard on it. And I would urge upon my lord and my lady to reflect on the numerous facts that we say were an issue. And so, hypothetically, if there was a case where there was only one potential outcome, and you have a situation where there is simply nothing that the respondent could say to avoid a conclusion that there, for example, had been unlawful detention, then it might fairly be said, well, there's no prejudice to you whether you're given an opportunity to be heard or not. I say, first, this is not that case by a long chalk, and it would be a fairly unusual case, my lord.
Well, that's effectively what's put to us, as I understand it, by Mr. Fitzgerald. He says there's nothing in it.
My lord, yes, and we say he's wrong for a number of reasons. Essentially, the reasons that were given by the Court of Appeal, and we say fundamentally you don't even start down that route until there has been a finding as to the sort of identity of the appellant and the identity of the person named in the return to the writ and the appellant, i.e. the link. They're the two aspects of identity that we're dealing with. And the judge, and I'll come on to deal under the third argument that deals with the evidence, why we say the judge did not make a finding. I think it is suggested by the appellants that the judge, in fact, made a positive finding as to identity. We say, well, that's simply...
But he ordered relief. He held that there had been a breach of the appellant's constitutional rights? Mustn't part of the underpinning of that be that it was actually him?
Well, my lady, I mean, that is the appellant's argument. They say, well, it's inherently improbable that you're going to get a judge granting constitutional relief to someone that they haven't identified who he is. But we say, when one looks at the judgment, that is precisely what the judge did, which is part of the problem. And it's paragraph 5 of the judgment where he clearly does not grapple with the identity of the appellant.
Standing back, and you say many facts are an issue. In order for the government to win, you'll have to show either that the applicant is not the person whom you repatriated and then brought back, or that you have found evidence to show that he had landed shortly before he was picked up in the street in order to invoke Section 26. Am I right about that, or am I wrong?
My lord, you are right about that. That would only go, the answers to those questions would only go as part of the relief that the judge granted. I mean, it would go to the lawfulness of the arrest, detention and removal. There were aspects of the relief that were granted as final relief that would be answered by the respondent without sort of answering those questions. So, for example, looking at the fact he was had not made an application for citizenship, may have been born in the Bahamas, but to non-Bahamian parents. His status and how that feeds into the final relief that was granted by the judge, which is effectively that he has been given de facto citizenship, right to work, and right to come and go in the Bahamas without interference. That's what the judge part of his relief.
I can see you can say that the particular form of relief may depend on matters which haven't been investigated. But so far as the lawfulness is concerned, your defence are those 2 points. The identity of the applicant and the fact that the government would have to show that he had been removed, that he'd landed a short time before they picked him up.
Well, yes, they would be the core issues that the respondents would have to address. There may be, and this is why it's difficult to give a definitive answer to your lordship's question, because it may be that when the respondents look at and interrogate the circumstances of the arrest, there may be other reasons why the immigration officer on the 18th of September 2017 stopped and detained the person that he or she did. But as I say, I appreciate. I mean, this is speculation, and this is why, for example, had the constitutional relief application been made at the same time as the habeas corpus application, and we'd have all come to court on the 9th of December, then the respondent would not have been relying solely on the return to the writ, and had they would have had to deal with the arrest, the detention, and the removal. And that's what they have not been given an opportunity to do. And in my submission, the reason that the respondent was sort of effectively taken by surprise by the approach of the judge, it wasn't just the respondent, it was both sides in my submission. If you look at the transcript, both sides expected that in the event that the habeas corpus application was dismissed, there would effectively be an opportunity to then deal properly with the constitutional relief application. And one gets that from the transcript of the 19th of December. If you go to page 196, lines 9 to 11, the appellant there accepts there is a factual issue as to whether the person arrested and who gave his name as John Charles is in fact Jean-Rony John Charles. The point is made again at 198 line 16, where the appellants say, if the return relates to Jean-Rony John Charles. And then at 204,
The other side.
the appellant suggests, and this was the point I think your lordships and my lady were taken to by my friend, at 204 lines 21 to 28, the appellant suggests the respondent ought to be given 21 days to come back to court and prove that Jean-Rony John Charles is actually the person repatriated to Haiti. That's then repeated in reply submissions at 229, line 4, where it is suggested that an adjournment, and we say that the court can do is to say to the respondents, listen, by your own evidence, there's confusion as to who this person is. We're going to adjourn. I'm going to give you an opportunity to satisfy me as we set off in our motion what the facts really are. And then at 2:30,
Who is speaking at that?
this is the this is Mr. Smith on behalf of the appellant. And it carries on at the bottom of the page, and over the next page to 2:30. If there is confusion as to the facts, let's come back. That can be determined on a subsequent occasion. And then finally, 233, the appellant concedes, with the current state of play, 233, lines 23 to 24, with the current state of play, it cannot, my lord, and cannot, that's a reference to, if one reads that couple of lines before, determine the rights between the parties. So the appellant concedes that on the evidence, there couldn't be a fair determination of the rights between the parties. And it was the expectation in my submission that what was going to happen, if the habeas corpus application was dismissed, is that there would then be case management to allow for a fair determination of the constitutional relief application.
And what would you have sought in a case management sense?
Permission to put in whether it... Sorry. What? About 233, lines 23, 24.
I see.
Sorry, my lord. To leave to put in evidence, so leave to put in whether it be witness statement or affidavit evidence and whatever documents.
And what would you have put in?
One would have, in the usual way. I mean, if you think of a sort of unlawful detention and removal case in this jurisdiction in a judicial review, you'd expect witness statements from the immigration officers concerned. You'd expect, given the allegations that were being made of the detention, you'd expect evidence from someone within the detention centre. And then we've got the surrender order. We've got two names on the surrender order. The government would possibly have looked to one of those people to explain the nature of the surrender order, why the surrender order was made. But there would have also been a challenge. I mean, leave aside the evidence that the respondents would have sought permission to adduce. The respondent should have been permitted to challenge the evidence that was being relied on by the appellant. And this feeds into the Court of Appeal's point that the nature of this case, given the state of the evidence, really can only fairly be determined by way of writ, discovery, witness statements, which is precisely the position we find ourselves in with the writ that's now on hold that was issued on the 28th of November 2018.
But you're accepting that it was perfectly competent to raise the application for constitutional relief by motion. You're not challenging that.
No.
You're just saying the way the judge handled it was unfair.
My lord, yes.
But you're saying that if he had introduced case management, you would have asked for an originating writ and discovery, etc.
My lord, whether we would have insisted on the sort of technical procedural point of it being converted to by writ, we would certainly been asking for disclosure and witness evidence.
Yes, you could have asked at any rate for it to for the proceedings to continue as if they had been commenced by writ.
My lord, yes. I mean, it is quite. You see very often in the administrative court in this jurisdiction where you have something started as a judicial review that raises issues of unlawful detention and removal, and the judicial review is often converted and moved to the QED to be heard effectively as a Part 7 claim, directions then given for disclosure and witness evidence.
You cite authority in your case from Ramanoop and an earlier case where Lord Hope gave the judgment. Yeah, to the effect that if there are factual issues in dispute, it's better to either begin by writ or at any rate continue as if by writ, rather than dealing with it on a summons.
My lord, yes, we say that this case is a very good example for the reason of caution that was given in Giroux and Ramanoop, and I won't take the board to it, but paragraph 37 of our written case, and we cite and in fact quote the relevant passages from Giroux and Ramanoop. And Giroux, Lord Hope says there, wholly unsustainable in cases which depend for their decision on the resolution of disputes of fact. Disputes of that kind must be resolved by using procedures which are available in the ordinary courts under the common law. And Ramanoop, Lord Nichols, similarly, an originating motion is a summary procedure, save in the simplest of cases, ill-suited to decide substantial factual disputes. Satisfactory resolution of such disputes usually require pleadings, discovery, and oral evidence.
Could I just take you back to 233, where you were saying that there was a concession that the parties weren't in a position to determine matters there? Above line 20, what is being said is that the appellant has provided a structure under the motion for the court to deal with it in a deliberate fashion. Is there a document which was being referred to there? Do you know?
No, my lord. I think that what is being said there is reference back to those earlier references where Mr. Smith was saying, well, look, the respondents can have 21 days to put in evidence.
It's a reference back to that.
Yes. There's no, as far as I'm aware, there's nothing in writing. But my lord, I mean, this feeds into a similar related point is the point that Malone and Friend made about the affidavit, suggesting that the respondents effectively had an affidavit up their sleeves that they were going to sort of only deploy at some later date. Well, rather than sort of assisting the appellant's case, that sort of underscores this point that I'm making about the expectation being that the respondents would be given an opportunity to file further evidence, because the exchange in the transcript, it's 193, line 27, when there's a discussion about this supplemental affidavit, was that it would only be relevant if we need to go forward in this application. The expectation, my submission of the respondents.
I thought people had read that as relating to the Ms. Martin's unfiled affidavit.
No, my lady, my understanding is that this exchange there at 193 is dealing with a supplemental affidavit that Mr. Smith raised that had not been filed or relied on by the respondents.
Oh, I see. You're looking at line 27 of page
193. I think it's 193.
There's
So this is the judge commenting that?
Yes.
Oh, no. Mr. Francis.
So, on this first argument, which is effectively the procedure for dealing with Article 2028, our point is a simple one. It's the law is not in dispute. It's that set out in the case of Jean Du. The respondents were not afforded, were not given notice, and certainly were not afforded an opportunity to putting the case why redress should not be granted. There are some specific criticisms made of the Court of Appeal that I propose to just deal with relatively quickly because they're set out fairly fully in our written case, paragraphs 17 and 18 of our written case, which is page 1542. Justice of Appeal Barnett's judgment is criticised first by the appellant. This is Justice of Appeal Barnett said that the appellant ought to have initiated new proceedings if he wanted to seek constitutional redress. Our first point in response to that is that Justice of Appeal Barnett was not laying down or purporting to lay down some rule of general application. All that he was saying is in the present case, given the state of the evidence, the appellant ought to have initiated new proceedings. And in light of his findings regarding the defects in Mr. Jean-Charles's affidavit, that was perhaps an unsurprising conclusion that he reached, and one that we say he was certainly entitled to. It's to be inferred in my submission that this is because he considered that there was no proper evidential basis on which the application for constitutional relief could proceed. So in other words, if it was going to go further, it had to be put into proper procedural shape. And the way to do that was by way of fresh proceedings by way of writ.
Paragraph 54 does seem to be worded, this is 1393, paragraph 54 does seem to be worded in fairly absolute terms. The court ought to have required the applicant to institute new proceedings if they wanted to seek that relief. An application for a writ of habeas corpus is a discrete action and should always remain a discrete action.
As I just submitted, I submit that that's not...
But you say it has to be read in the wider context.
It does have to be read in light of what the judge has said earlier about the state of the evidence in this case. And if that was trying to lay down or laying down a rule of general application, I say Justice Appeal Barnett would have made that clear.
Okay.
Even though, I mean, if I'm wrong about that, and even if Justice Appeal Barnett was suggesting that in every case of this nature, new proceedings ought to be initiated, that was but one reason, I think, of three reasons that he gave for finding that the judge erred in addressing and considering the constitutional relief application in the way that he did. And I'm going to deal with his other two reasons. That's unresolved identity and unfairness when dealing with the later arguments that the appellant advances. Briefly turning to the criticisms made of Justice of Appeal Isaacs, what the appellant's criticism turns on is what he says at paragraph 85 of the judgment, page 1406, where he says that an application for contempt and/or constitutional relief cannot resurrect the application. Now, it's clear that the application there is a reference to the habeas corpus application. And in my submission, on a fair reading of that, all that's being said is that once a habeas corpus application has been dismissed, it cannot be resurrected by means of an application for constitutional redress. And that's uncontroversial. What he's not saying is that having dismissed a habeas corpus application, one cannot then go on in certain cases to deal with the constitutional relief application.
Well, an application for habeas corpus is not necessarily an allegation that someone is being unlawfully detained. It's requesting the detainer come to the court to explain why the person is being detained. Whereas, of course, underlying a claim for constitutional relief, there is an assertion that the person is being unlawfully detained.
My lady, yes, and we say that's why the way in which the judge dealt with the evidence in this case and effectively regarded the return to the writ, which, as your ladyship says, is focused on the habeas corpus application. That's its only purpose, is dealing with the question of have you, the government, got in custody either Jean-Rony John Charles, date of birth 1982, or Jean-Rony John Charles or Jean-Rony different date of birth, and that's what it addresses. It doesn't address the lawfulness of detention. And just on this final point on Justice Appeal Isaacs, we say if you read paragraph 68 and 86 and 88 of the judgment, which is 1407, it is quite clear that the judge is there drawing a distinction between the application for contempt that was also made and the application for constitutional redress. The former, the application for contempt, he considered fell away when the judge dismissed the habeas corpus application, but the latter did not. And it's quite clear from those paragraphs that the judge did not consider that determining habeas corpus precluded the judge from hearing the application for constitutional redress. Moving then to the second argument relied on by the appellant, and this is evidence, effectively, the evidence relied on by the judge, and I don't seek to repeat anything I've said already. In short, we say that the evidence was wholly inadequate to support the final declarations that were granted by the judge. Just give the board some references to some cases that we have set out in our written case that are, I think, uncontroversial propositions. That paragraph 22 of our written case, 1545, we refer to the well-known case of Minister of Home Affairs and Fisher, and we accept that in construing constitutional provisions, a liberal approach is required to give individuals the full measure of their rights and freedoms, but that interpretive principle does not free an applicant from the requirement of having to substantiate a constitutional claim both in law and fact as to breach. And we refer, in the next paragraph, paragraph 23, to a Canadian Supreme Court case of Danson, which the board has in the Authorities Bundle 1896. And it's simply for what is said at 1910 by the Supreme Court. This was a case that considered the evidence required to establish the breach of a charter right. And having drawn distinctions between adjudicative facts and legislative facts, the Supreme Court says in 1910, charter decisions should not and must not be made in a factual vacuum. To attempt to do so would trivialise the charter and inevitably result in ill-considered opinions. The presentation of facts is not, as stated by the respondent, a mere technicality. Rather, it is essential to a proper consideration of charter issues. Charter decisions cannot be based upon the unsupported hypotheses of enthusiastic counsel. And we say, properly analyse the evidence that the judge relied on consisted largely of generalised allegations, second-hand evidence, and unsupported hypotheses. And we then set out Giroux and Ramanuk that I've already taken board to. I've addressed what we say the judge ought to have done. Move then to briefly address the specific errors in the judge's approach that we deal with at paragraph 26 of our written case. I mean, essentially, what we say is when one looks at the judgment, particularly paragraph 20, where the judge lists what he describes as undisputed facts, and then grants relief on those undisputed facts, throwing in at the end, paragraph 38 of the judgment, a further finding that the appellant had not left the Bahamas. We say there are several procedural and substantive errors in that approach. And we set out 6 of those at paragraph 26 of our written case, page 1546. And briefly taking those now, I can take the first 2 points about the evidence together. The affidavit of Miss John Charles was sworn on 28th November 2017. It was sworn, as it states on its face, in support of a writ of habeas corpus, constitutional motion not filed until 19th of December 2017. That affidavit, we say, could not have been sworn, obviously in support of the constitutional relief application that comes later.
Why does that matter?
Well, because, my Lord, if it was to be relied on in support of the constitutional relief application, then it was incumbent on counsel for the appellant to seek leave of the court to rely on it, or for the judge to make it clear that he was going to rely on that affidavit when determining the application for constitutional relief.
So there's no objection in it in principle as evidence, but you say it's unfair that you weren't given notice of the applicant's intention to rely on it.
My lord, yes, and the point is this: had either the appellant made that application or the judge had indicated that was his intention, then the respondents would have, at that point, sought to either make an application to rely on its own evidence or challenge that evidence or make an application to cross-examine the appellant.
Okay.
The third and fourth point in the evidence, again, I can take these together, short point. One I've made already. The affidavit of Miss John Charles, we say when one actually looks at its contents, consists of little else than general assertions and a lot of hearsay. It's a point that the Court of Appeal make, and this is leaving aside its formal defects from a habeas corpus application point of view. The fifth point in the evidence is the return, and this is a point goes to what my Lady Rose made a moment ago. The return could not be relied on as affirmative support for the appellant's claim for constitutional redress in my submission, because it was addressing an entirely different sort of application, namely habeas corpus. Its focus was not on allegations of constitutional redress. And then the sixth and final point, probably repeating one I've just made, that if the judge was going to rely on the affidavit, then he ought to have made that clear, and that would have prompted the respondents to make its own application. Finally, on the second argument...
Sorry,
my lord.
Why do you say the return couldn't be relied on as affirmative support? I mean, what legal proposition do you have in support of paragraph 30?
Well, my lord, really, I suppose it's a forensic point that if what is said in the return, if the purpose of the return is to address the question under a habeas corpus application, namely, is the person in custody or not, then you risk the evidence effectively being like ships passing in the night, and it's not. The return is not addressing specific allegations that are made in the constitutional relief. So I suppose I'm not saying as a proposition of law it cannot be relied on as evidence. I suppose it goes to the weight that the judge attached to it, and when one looks at his judgment, he says in terms that he's treating the return as effectively.
But that return told. It told those acting for the appellant what had happened if the person who was removed to Haiti and then later brought back, it told them that he wasn't being detained because he'd been removed. I mean, as evidence of fact, why is that not available to be cited against the government in an application for constitutional relief?
My lord, as evidence of that fact, and that's why perhaps the submission I made was too wide in its scope. It's effectively that because it is addressing the question of custody, it is not addressing wider aspects of the application of constitutional relief. So that there are certainly facts within the return that the judge was entitled to rely on, but only, we say, could he fairly rely on that if the respondents were given an opportunity to address the constitutional relief application.
Oh yes, that's a different point. Yes, I mean you make with some force the point that you weren't put on notice that Clotilde's affidavit would be used against you in constitutional relief, or that the return would be. But insofar as they recorded the government's position on certain factual matters as evidence, there was perfectly competent evidence to be used.
Yes.
Yes.
But your point is that the judge was wrong in treating that as all the government had to say.
Yes.
in opposition to the relief claim, although it would be legitimate to treat it as all that they had to say in response to the habeas corpus application.
Yes, my lady, and it may be, getting back to Lord Hodge, yes, there may be facts asserted in that return to the writ, but in the evidence in response to an unlawful, constitutional relief application, those facts may become more nuanced. So that, for example, there may be more to say about the return. There may be more to say about the stop and search and stop and questioning. So the return to the writ was focusing on this question of custody. Very briefly, because we say the judge was wrong to make a finding effectively that there were no disputed facts. We say we've looked at the return and the affidavit. It is worth perhaps just drawing the board's attention to the notice of motion itself. And we've listed at paragraph 35 of our written case, which is 1549. The notice of motion is page 100, but it may be just as easy to look at paragraph 35 of our written case, where we set these out. Paragraph 4 of the notice of motion indicates that whether or not the appellant has in fact been deported, quote, remains an issue of fact and is not conceded. Paragraph 6, the return, quoting, the return made by the respondents is insufficient in that it fails to properly establish Roman 1, the person referred to in the return is in fact the appellant. Paragraph 13, the return does not establish with any certainty the person alleged to have been deported was the same person as the applicant and is still not detained in the Bahamas. And then paragraphs 15 and 16, again, they repeat the point that it's not conceded that Jean-Rony John Charles has in fact been released in Haiti. So those facts were put in issue by the appellant's own notice of motion. As well as there being an issue as to identity, which I'll come on to in a moment, the board has the point that there was an issue as to whether the appellant had left the Bahamas. I've probably said well, I suppose make this point. When one looks at the judgment, it appears that the judge is effectively treating the birth certificate as de facto evidence of citizenship. And what he certainly does not do or record anywhere in the judgment is details such as the fact that Jean-Rony John Charles, on the evidence, even if he is born in the Bahamas, was born to non-Bahamian parents and has not made an application for citizenship. And at the very least, we say the judge ought to have considered the exception in Article 25(2)(d) of the Constitution, which is the article that provides that anything done on the authority of any law imposing restrictions on non-citizens is not unconstitutional. Move then to the appellant's third argument. So this is identity. And given what I've said already, I'll probably take this fairly quickly. The appellant's main contention is that the Court of Appeal was wrong to allow the appeal on the basis that there was still uncertainty as to identity. And there's 4 parts to our response. We set these out in paragraphs 39 to 51 of our written case. First, we say the appellant is simply wrong to suggest identity was not in issue either at first instance or the Court of Appeal. Second, we say the appellant's wrong to say that there was a concession that the respondents had ascertained the correct identity of the person stopped, detained, removed to Haiti is the appellant. Third, we say it's clear from the transcript and the judgment of first instance that the judge did proceed on the basis that he need not resolve the issue of identity before granting constitutional relief. And fourth, we submit the Court of Appeal was plainly right to hold that the judge erred in that regard. Just making good those 4 points. Identity before the judge. I've already shown the board that the application itself, notice of motion, and the return to the writ both put in issue whether the appellant was the person that had been detained and removed to Haiti. just looked at the motion for constitutional relief, the best part of the return is paragraph 13, which is page 54. Says at the material time there was no record or conclusive evidence confirming or reason to believe that John Charles, date of birth 1st December 85, based on the information he provided to the authorities and or the subject of risk, Jean-Rony, John Charles, are one and the same person. So there was plainly in my submission a dispute before the judge as to whether the return referred to the treatment of the appellant. It's wrong, we say, for the appellant to try and suggest otherwise. But the transcript of the hearing highlights that issue too. And if I can just give the board some references. Page 209, lines 3 to 5, Mr. Smith states that the return doesn't necessarily as a certain fact relate to the same person. Page 212, lines 7 to 8, Mr. Smith refers to Jean-Rony, John Charles, quote, or this man, John Charles.
One needs to be careful not to open up some hole into which people will fall. One can envisage egregious situations in which habeas corpus is absolutely the right way to go, where someone has been detained, they're held incommunicado, their relatives are not told where they are or whether they're detained, then they're thrown out onto the street, and then the government says, well, prove to me that it was you who was detained. And the person has no ability to do that, the board needs to be careful not to create a crack through which serious injustices might fall. So what is it that distinguishes this case from any case where the government might say, well, you prove that it was you who we took because we say it wasn't you, it was somebody else. We're not prepared to say who.
Well, my lady, I'm only asking the board to determine this, obviously, on the facts of this case, and I say the board can readily determine it on these facts when one looks at the immigration profile report, profile form, and the affidavit of Miss John Charles, and it's the unexplained discrepancies between those two documents that is really at the heart of this.
So you would accept that there has to be some question arising from the documentation to challenge the identity of the person?
My lady, yes. And Linford was asked, well, rather put the point, well, what was the judge to do? The judge could have ordered the return from Haiti of this person and then gone on to determine if the concern was there's someone still languishing in Haiti that shouldn't be there, then interim relief could have been granted for that person to be brought back, and then the constitutional relief application determined. That would be perfectly proper. But the point I'm trying to make at the moment is it is being said effectively by the appellant. Well, respondent is just is wrong because there was no issue at first instance, and there shouldn't have been an issue in the Court of Appeal as to identity. And I said, well, there clearly was, and one sees that from the appellant's own submissions in both the first instance in the Court of Appeal, and it's something that the judge ought to have dealt with.
Well, the judge appears to have thought that the only issue was as to the applicant's name and date of birth, and not as to the identity of the applicant.
Well, so is that paragraph 5?
I'm looking at paragraphs 20 and 21 on page 355.
Well, I think it's difficult to draw that conclusion when one reads what's said at paragraph 5.
I'm not suggesting that the conclusion was correct or was even reasonably justified. I'm saying that seems to be the view the judge took. Paragraph 20 he's considering the return. He says the return accepts the facts outlined in the affidavit, save for disputes as to the name, Jean Charles, as opposed to Jean-Rony Jean Charles, and the date of birth of the applicant. Then paragraph 21, it is undisputed that the applicant was arrested. Now, what you're telling us is the whole point that was in question was whether the person who was arrested was actually the applicant. It wasn't simply the name and date of birth that were in issue, but whether the person who had been in the hands of the immigration officials was actually the same individual as was the applicant in these proceedings.
My Lord, that was plainly in issue.
And even if it was, then the judge missed the point.
And I say one has to read that with what the judge says earlier at paragraph 5 of the judgment.
Well, he's lost sight of that, I think, by paragraph 21A.
I mean, this is the
A, B, C, and D.
Because prior to the judge handing down judgment, there was a further hearing on the 27th of January, and at that hearing, I think it's 284. Mr. Smith makes a submission. He says, "My Lord, you may recall that there was some dispute on the facts as to who or was not removed from the Bahamas to put in actual terms. As your Lordship has not yet delivered a ruling, I wish to simply give an indication to my learned friend. We intend to ask leave of the court to file additional evidence to clear that issue up. Your Lordship may have seen that in the papers." And then the judge says, "I don't think I need to hear anything further."
Well, he says, "I do not wish to get into that issue at all."
Which, in my submission, supports what we say and what the Court of Appeal found, which is that the judge did not resolve the issue as to, and perhaps it's wrong to call it an issue as to identity. It's really the issue as to whether the appellant was the person person that was detained in September 2017.
Yeah. Well, that's really what, yeah.
And the appellants go further and they say, well, certainly by the time we get to the Court of Appeal, that issue had been resolved. And again, we say, well, that's not right. The transcript we've set out quite fully at paragraph 43 of our written case. It's 1552. And the reason we've done so is, in my submission, it repays reading, particularly the exchange regarding the judge's preferring the appellant's sort of evidence. But there's 3 points that we make on this exchange in the Court of Appeal.
Could you give me the page number?
So, my Lord, the actual transcript starts at 1009, line 20, and runs some 6 pages to 1015, line 23. But as I say, there's a fairly, there is an unabridged extract of that at paragraph 43 of our written case, which is 1552. But there's three reasons we say that's an instructive exchange, if I can put it that way, in the Court of Appeal. Because first we say it shows the appellant conceding that there was an unresolved issue before the judge as to whether the appellant was the person that had been detained and removed to Haiti. And that concession is perhaps most clearly made at 132, lines 2 to 7. When Mr. Smith was asked by the President whether the substantive issue as to whether or not the person before the court was either John Charles or Jean-Rony remained a live issue that has not yet been resolved, and Mr. Smith said, it was, I cannot escape that. Second reason we say this exchange is instructive is we say it undermines the argument that the judge did, in fact, decide this issue of identity. Now, we say paragraph 5 of the judge's judgment and that exchange we've just looked at from the hearing on the 27th of January, rather suggests that the judge didn't feel he needed to resolve this. But that is the correct reading of the judgment is supported in my submission by Mr. Smith's understanding, which we can see from this transcript, that the judge could not determine the issue on the evidence. And so if you look at 1137 line 20, Justice of Appeal Barnett puts to Mr. Smith that what the judge is saying at paragraph 5 is that there is uncertainty as to whether or not the person that applied for habeas corpus is in fact the person who was in custody. And it's been said by the appellant that the respondent effectively conceded this issue in the Court of Appeal. Well, the best place to look for precisely what was conceded by the respondent is what we've set out in paragraph 47 of our written case. It's the transcript reference is 971 line 8 to 972 line 5. And the exchange, this is the respondent's counsel in the Court of Appeal. And it's put, are you now conceding that this is in fact the person? What we're conceding, my lords, is that the person who was in the detention centre and who was removed has been returned. We are not conceding that we have ascertained the correct identity of that person. Okay, but are you conceding the person who has been expelled has been returned? It is the same person who brought him back. So, my lords, that will come later. What we're saying is this. There was a person in the detention centre. There were questions concerning his birth documents. That person was removed and that person was returned, facilitated by the state, but actually returned by counsel. Nobody has made any concessions concerning the authenticity or anything about the specific person. Those facts are yet to be resolved. So in the circumstances, the Court of Appeal was plainly entitled, and it submitted outright, not to resolve the outstanding issue of identity itself. It's next suggested, I think, by the appellant that if the Court of Appeal did consider that there was some uncertainty, then the Court of Appeal should have remitted the matter for retrial on that basis. The point we make in our written case, paragraph 50, is that's a slightly surprising submission because the appellant's position in the Court of Appeal is that a retrial would be, in their words, an exercise in futility. That's 1039, line 20. So given the Court of Appeal's findings as to the evidence, the inadequacy of the evidence relied on by the judge, and the appellant's position as to retrial, it's unsurprising that the Court of Appeal did not order a retrial. Move then to the fourth argument. This is fair hearing. There's two parts to the appellant's argument here. First, it said that...
Isn't it your case that there does now have to be a trial of this?
My lady, not as... there may well be a trial following the writ that's now being issued, but our primary case is that the board should dismiss this appeal, the Court of Appeal being right to uphold the appeal and set aside the judge's orders. Now, given that a writ has been issued in November 2018, then that writ, I'm assuming once this appeal is determined, is going to be revivified, and there's going to be directions given for the hearing of that. But I'm certainly not inviting the board as our primary case to remit this for a retrial. I say that the Court of Appeal was right to make the findings it did and uphold our appeal. If you're against me, and if you were to allow the appeal,
if we were to dismiss the appeal, that's not the end of the road for the applicant. That's right, my lady. And that's precisely why the writ was issued, and it pretty much says as much in the November 2018 writ.
Fair hearing, there's two parts. The appellant contends that effectively we have waived the right to complain about any unfairness because we didn't seek an adjournment, and second, that we didn't suffer any prejudice. Deal with those in turn. The adjournment point, we deal with this paragraph 53 of our written case, 1558. We set out 4 points there, just briefly. We say the judge had a duty to actively manage the proceedings to ensure just resolution. That would obviously include adjourning any part either on the request of a party or on the court's own motion. We said no answer to our complaint of unfairness to say we ought to have applied for an adjournment. The judge ought to have appreciated that he couldn't fairly determine the constitutional relief application without allowing respondents to be heard on it. Second point is a point I've made already, which is that it was our reasonable expectation, and in fact the appellant's expectation, that there wouldn't be a final determination of constitutional relief without some form of further hearing if the habeas corpus application was dismissed.
So you would have dealt with it on the return day, would you, when the judgment was given? How would you have done it?
I think what was envisaged would have been that the judge would give his judgment on, I suppose, three aspects: the habeas corpus application, the contempt, which goes hand in hand, and then the respondent's point on alternative remedy. And having dismissed all three, the expectation would be directions given for evidence and then hearing.
Pursuant to the originating motion that had been lodged on the morning of the 19th of December.
Yes.
Hence no application for an adjournment in the meantime.
Yes. The third point is, I think, is a point I've made already about the supplemental affidavit. We say that rather suggests that the respondent envisaged there being a further hearing on the constitutional relief application. And then the fourth and final point, we say when one looks at the transcript of the hearing on the 19th of December, this is plainly not a case, as is being suggested, of the respondents illegitimately trying to have two bites of the cherry or feigning being taken by surprise by the procedure that the judge adopted. We say, on the contrary, this is a case where an unfair procedure was adopted to the surprise of both parties, and then, contrary to good practice, it resulted in unfairness and prejudice. So, dealing with prejudice next, we've set out paragraph 54 of our written case. What we say the prejudice is, take the 3 points quickly. First, procedure adopted by the judge meant, obviously, we weren't given an opportunity to make submissions. Had the judge adopted a fair procedure, at the very least, we would have sought to challenge the evidence relied on by the appellant and make submissions in line with those made to the Court of Appeal on the substance of the application. Second, I think, as I've already said, we say the appellant is wrong to say that those facts that were listed by the judge at paragraph 21 of his judgment, which he describes as undisputed, say it's wrong to describe those as undisputed or justified by the information in the return to the writ. And then third and final point, that there were many unresolved issues of fact that the judge was wrong to assume in the appellant's favour. We've set out examples of those at paragraph 54, little c of our written case, which is page 1560.
Certainly, 54C, items 5 to 7 will be matters peculiarly within the knowledge of the government, immigration service.
Well, there are facts that are would be expected to be within the respondent's knowledge.
Yeah, but you say that you hadn't been given the opportunity to air them.
No, my lord, not on the 19th of December.
Can I ask, have the government filed any defence to the writ?
The writ has been put on hold immediately.
Is the government going to challenge the suitability of the writ as a method of seeking relief?
Sorry, my lord. Lord, so my understanding is, because it's a generally endorsed writ, all the government has done is enter an appearance, and the next stage would be a statement of claim.
Yes.
We haven't got to that stage yet because it's effectively, I don't know if there's an order to this effect, but I'm
just
told that
wondering
it's been stayed.
how much longer you're going to hold all this up. Are you going to be filing a defence to the effect that this is a wrong way of proceeding, that it should be an action in tort, perhaps, for false imprisonment?
Well, my lord, I think the generally endorsed writ suggests it is being advanced as an action in tort and also as an action under the Constitution. I would be I don't want to tie the respondent's hands, but I would be very surprised, given what the Court of Appeal has said, if the government was to take the position that a generally endorsed writ is the wrong way to go about seeking redress. My lady, I suppose the only final point is just on disposal. The Court of Appeal has not determined grounds 1 and grounds 5 to 9 of the appellant's notice. Ground 1 was that the application for constitutional redress was an abuse, and grounds 5 to 9 went to the substance of the application for constitutional relief, so questions of lawfulness of detention and removal. Now, the Court of Appeal obviously didn't need to determine those grounds. If the board was against me and was to allow the appeal, then those grounds of appeal haven't been determined, and so one course would be to remit to the Court of Appeal for the Court of Appeal to determine those grounds. Obviously, the other course would be to remit for a retrial at first instance. But that's only obviously if you're against me and find favour in the appeal. I don't think there is any question of the board deciding for itself those grounds of appeal. Both parties have, in my learned friend's written case, in an annex, they've addressed provisions of the Immigration Act, and we have addressed those issues by reference to the submissions that were made in the Court of Appeal. As I say, I don't think there is any risk of this board determining those grounds of appeal. What we do say is there is good reason for this board not to, because you haven't had the benefit of the views of the local Court of Appeal, and given what is said certainly by the appellant of the importance of these issues, and I referred you to some press articles earlier, 496, it was suggested that the judgment at first instance paves the way for people born in the Bahamas to non-nationals to seek protection from unlawful expulsion. We have cited the case of Baker, which will be well known to the board in our case, written case, and we say that in line with the board's normal practice when faced with points such as this being raised effectively on appeal to the board, having not had the benefit of local Court of Appeal determination, we'd urge the board not to determine those substantive issues. My lord, my lady, unless I can be of any further assistance, they're my submissions.
Can I just raise one thing which I didn't quite catch? You said a while ago that the birth certificate should not be treated as evidence of citizenship or entitlement to citizenship. And then you referred to something, I wasn't quite sure if it was a provision of the Constitution, which I think you were suggesting says that things might not be unconstitutional if done to non-citizens. Could you just explain?
Well, that's
the proviso, isn't it, to Article 25?
Well, it was 25.2. The article I had in mind is 25.2d. So nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision. And then D, for the imposition of restriction on the right of any person to leave the Bahamas, of any person who is not a citizen of the Bahamas, or the exclusion or expulsion therefrom of any such person.
But to bring yourself within that, you would have to set up your claim under Section 26 of the Immigration Act, that the applicant, if it be he who you detained, had landed a short time before in the Bahamas.
Yes.
Thank you.
Thank you, Mr. Court. Ms. Fitzgerald.
Yes. Hello, my lady. On that point, obviously, it would have to be done under the authority of the law, and that's the whole question. It would have to be lawful. And can I just on that point, there was no part of the judge's ratio that this was someone who was a citizen. And indeed, if one looks at the provisions of the Constitution, so the provisions of the Constitution that were being relied on, they are no person in section 19(1) shall be deprived of his personal liberty, and 25(1) no person shall be hindered in enjoyment of his freedom of movement. So, one, they going on about there is an issue about citizenship. The judgment of the judge did not rely on the fact that he was a citizen. He relied on the fact that there was evidence that he was born and had not left, because obviously that could be relevant to the question under section 25. So we're talking about setting up straw dogs or straw whatever it is. This is a complete red herring. For them saying we need to resolve the issue of citizenship at this hearing, you don't. No person is not no citizen. No, in 19(1, it's not no citizen. In 25, it's no person. And the judge, you won't find anywhere in his judgment him saying he is a citizen and therefore. It's simply, if you are going to deport someone, there is a lawful procedure which has been gone through in countless cases, including Jean and the Minister of Immigration, which we've referred you to, and Takitoko, who is a Japanese citizen, and this has not been done in this case. And so, my lords, my lady, that's our first point. There's a reference to some footnote in their case about the brothers and sisters. In fact, that was ruled inadmissible by the Court of Appeal at pages 1285 to 1287. And really, if one looks at that, that is indicative of the quality of piling speculation on speculation, which is the only basis on which they are saying that there could be some justification for what is done. One has the judge who, my learned friend has now accepted that, contrary to what one might regard as a reasonable reading of what the judges said about you can't convert it, you have to start again, and you can't resurrect it. But he said that he accepts that the evidence could be used. He says he accepts that the evidence of Clotilde could be used. He accepts the return could be used. There's no bar on that. And then the judge, based on that, makes findings. And the findings are that there is no justification. See paragraphs 32 and 35. And we respectfully submit that all my learned friend has been able to say is there may have been, possibly, some unexplored and undiscovered evidence that he landed in breach of some regulation, and therefore he may qualify for deportation. With great respect, this is where we say there's an air of total unreality and speculation. A judge, on the evidence, on the basis of the return provided by the government, and on the basis of Clotilde, his sister's affidavit, makes findings. And the government say, oh, that's terribly unfair. We might have had something to say. What would you have had to say? We might have had scenario 1, oh, but that doesn't apply. We might have had scenario 2, so 41 doesn't apply. Section 19, oh, that doesn't apply. Oh, well, and in answer to my Lord Hodges' question, there might have been scenario 3. Then the court examines with my learned friend, well, let's look at this scenario 3, section 25. You've got to have landed. No evidence of that. Oh, no, there's no evidence of it. But he might have had a travel document at some time. He might have travelled in breach of that travel document. He might have landed in breach of that travel document. He might have been found within 2 months of that arrival. It's simply, there's nothing to try. There's no doubt that if they had anything, they would have provided it to this court and they would have disclosed it. And this, in our respectful submission, is simply an exercise, a very able exercise, if I may put it that way, in saying, in playing for time. And that can't be what justice is about. I mean, it's obvious that the judge got it right in our respectful submission, that the Court of Appeals footling complaints about Clotilde, everything she says, and when she says, I went to the thing and gave in the documents and I asked them what was happening, that's her giving evidence. When she says this is their response, that's her giving evidence. The idea that there wasn't evidence before the court in that or in the return, it is fantasy, with great respect. And so we do respectfully submit that, as my Lord Hodge put to my little friend, right, where are we? What is in dispute? What is the evidence that what is the possible justification? We really ended up with, well, there might be something under Section 25, but I can't tell you about it. We say that the principle in Huddleston, once you're in habeas, once you're in constitutional proceedings, is pretty fundamental. What is the basis for the arrest? What is the basis for the detention? What is the basis for the removal? They've provided nothing. And my lords and my lady, then there was a lot of nonsense about it can only be determined by writ. O'Reilly and Macman in 1982 made it absolutely clear that you don't have to commence by writ, and indeed all the remedies can be provided under public law. The same must apply with all the more force to a motion under the Constitution, and indeed there are constitutional applications in which there are issues of fact which are determined in the courts of the Bahamas and elsewhere. The problem is the absolutely massive delays, and quite frankly, it fills one with horror, the idea that this is going to go and start all over again. At least here was a judge who actually did justice and did it on time and in a timely manner. The idea that, I mean, I've got a constitutional motion outstanding for 4 years for determination in Bahamas, and you've got the case that gave rise to it, which was when the president said this must never happen again when Samuel Knowles was renditioned. We brought a constitutional motion. We're still waiting for the judgment to be given 4 years later, despite a judge actually does something, and now it's, oh, he should have delayed more and more and more, and the Court of Appeal come up with their technicalities, and oh, he should have postponed it. And with great respect, what for? I mean, I suppose the board could say to my learned friend, well, if you've really got something, give it to us in the next month, and otherwise, that's it. Because at least one has got a determination here of some issues, rather than yet more delay. And my lords and my lady, I do respectfully submit that is of crucial importance. If one looks at what Justice of Appeal Barnett said, an application which my Lord Hodge drew attention at paragraph 54, an application for habeas corpus is discreet and must always remain done. That sounds like laying down a rule. Certainly was interpreted that. And Mr. Justice Isaacs, you cannot resurrect habeas corpus in other proceedings. That certainly sounds like a bar. So I do respectfully suggest that left unmolested, those dicta do not sound like and will not be treated as, oh, well, that was just a remark on the particular facts of this particular case. Then my learned friend's second point, so first of all, he said there was no error of law. We respectfully submit that there was in the way that we've identified. Then he said that the evidence was inadequate to justify the findings. I think I've made my submissions. The cured, as it were, affidavit of Clotilde, which the judge admitted, did justify those findings when taken in conjunction with the Akira Martin affidavit and the return. And there could not be better evidence than the return of what is the justification for detention. It is this, and this is... Now, my learned friend keeps saying, well, we might have said something different, but we do refer to that White Book extract. If you're going to say, when you haven't asked for an adjournment, we might have said something different, there must be some duty, particularly on the state, to identify what is it that they would have said. And my learned friend, with great respect to his eloquent advocacy, has identified nothing. So then it's criticised the undisputed facts, but if one goes to those undisputed facts that the judge came up with, they remain undisputed to this day. I would invite, it is undisputed that the applicant was arrested. Well, there's no real dispute that somebody called Jean-Rony Jean Charles, who is the applicant, was arrested. In fact, they refer to him as Jean Charles, which is his surname, and on the manifest he's referred to as Jean-Rony, Jean Charles, aka Jean-Rony. The applicant was never charged. Again, the idea that they wouldn't have referred to it in the return if he had been charged is to be frank, utterly fanciful, never taken to any court. Again, that's right, no deportation order or detention order was issued. Again, they would have referred to it in the return, or they would have, my learned friend would be saying now, well, here's the detention order, or this shows how strong our point is. Was put on a plane involuntarily, there's no doubt about that. He was accompanied by the Defence Force, and the reason for his arrest or detention is stated as follows. That's correct. We respectfully submit all of those facts are justified, those findings are justified, and that then if one looks on to his findings at page 362 onwards, my learned friend hasn't responded to paragraph 32. The Director of Immigration can't authorise the removal, certainly in these circumstances. He then deals with Article 25 of the Constitution and makes his findings about unlawfulness of deprivation of liberty and expulsion at 34 to 35. My Lords, my Lady, I have accepted that the one direction about issuing status as would permit him to remain in the Bahamas and legally seek gainful employment, although it was taken from the order in the Takitoko case, the board could state that goes further than is necessarily justified by the findings that have already been made. But you won't see anywhere there a finding that he is a citizen. So then if one looks at, my learned friend then said there were these, so on those facts we say the judge's judgment was justified. The Court of Appeal, apart from saying there should have been more case management, has identified nothing. And the Court of Appeal, insofar as they said that identity needed to be established, we do submit that there was and is no basis for the government to say that Jean-Rony Jean Charles, the applicant in these proceedings, was not the person detained and expelled. That the debate is about the date of birth. Did the person who is the applicant in these proceedings, whose first name is Jean-Rony, second name Jean Charles, give a false date of birth? And I think I may have, I did give evidence, my Lord, on that. Can I correct the evidence I gave? And again, you may want to disregard this totally, but I've got a duty to the court. My understanding is that he did initially give that thing, but then corrected it later when he was in Carmichael Detention Centre. And that perhaps, so he gave the wrong thing because he was frightened, and then later, when his sister provided all the documents, he provided his correct date of birth. Now, is the punishment for giving the wrong date of birth that you're debarred from all constitutional relief? And is this, can one really see this, looking back now, as just a detail? So obviously it helps if you give the right date of birth, but his sister had given the right date of birth, and it was given at a later stage. I respectfully submit that the only issue that's outstanding is, did he give the wrong date of birth? And it certainly would appear that he did, and what's the reason for that? But that's it. And so the issues of identity then go away. And of course, sometimes it's easier to look back in retrospect, but if it turns out that the judge is correct on substance, why interfere with him? Because if you look at that salutary rule in the White Book, which is if you're going to say we were taken by surprise, and you don't actually apply for an adjournment, you've got to identify some real prejudice, something that you would have said that would have made a difference, which is really a very general rule. And we would respectfully submit that that should apply here. So, my Lord's Melody. Yes. Oh, yes. Yes. My learned friend Frederick Smith says that Far Trail Road is not on the beach. It's next to Carmichael Road, where the detention centre is. But I mean, since my learned friend was speculating that it might be on the beach, I mean, it isn't. And being picked up there does not carry with it a presumption that you've just landed on the beaches. So those are our submissions, which, as my Lord Kitchen put to me, our principal point is the judge was substantially correct in every finding he made, and correct to find there was no justification for detention and no justification for expulsion. That if one item of remedy went beyond what was strictly, there might have been something one could have said on that, then strike down that one item of remedy, the item 4, an order directing to issue such status. But he was right to order his return, entirely right. And actually, this is exactly where the Constitution comes in. The kind of remedies that the Constitution has developed, which are far more extensive than anything under a writ, are precisely the kind of extensive remedies that you need to invoke in order to say to a state, well, you've got to bring him back. I mean, it's debatable. As a result of Ramatullah, you could do it under habeas corpus, but you certainly can do it under the Constitution. But the idea that this should be by writ is, in our respectful submission, wholly misconceived. The whole idea of the Constitution was it introduced a wider range of remedies for a wider range of injustices not necessarily caught by the old torts. And Lord Scarman has put it in his great dissent in Riley, the Attorney General. He said, once you've got the Constitution, then the principle ubius ibi remedium applies, and the Constitution will fashion new remedies for injustices which perhaps couldn't be addressed in the past. So, my Lord's Melody, those are really our submissions, and if the board were to be against us on upholding the judge's order, then we would respectfully submit that it should be remitted to the judge continue. But the one thing that was wholly unjustified in the circumstances was to simply quash the judge's finding and not even remit it for retrial. And my own friend says, well, you didn't ask for it, but well, often one asks for the moon, but that doesn't mean the judge shouldn't. I mean, it's like saying if you go for an acquittal on murder, the judge doesn't have to direct on manslaughter. Lord Bingham says that's nonsense in the case of Coots. That's what a court's there for, to say, well, I'm not going to give you the whole hog, but it's right to give you the half a hog, you know. And so we respectfully submit that is the reason why, were we to fail on upholding the judgment in near totality, that would be the alternative. And it would vindicate the point that it is right to bring a constitutional motion, that the evidence that was already there is part of that constitutional motion, and that if the respondent does indeed have evidence to put in rebuttal, and we rather suspect that they're just playing for time, and postponing a politically untoward result, then in our respectful submission, that they can put it in, or they can make their speculations about Section 25 all over again. But we do respectfully ask, well, what else are they going to do, which they couldn't have done in the last 4 years? My Lord, those.
Thank you very much, Mr. Fitzgerald. Well, this is obviously an unusual case, and it seems as though it may potentially have wide consequences. We'll consider all that's been said and consider the advice that we will tender to Her Majesty. Thank you. The court will adjourn.